Which came first, the states or the federal government? An even better question should be who created whom? Did the federal government create the states? No, the states created the federal government when it ratified the Constitution. So if the states are the parents of the federal government, why are they not sovereign over it? One state legislature tried to pass legislation to reassert their position as sovereign over the federal government. Sadly, that measure did not pass. Yet. So we'll look at this legislation next on the Constitution Study.
Lovely neighbors and have a few good friends. Every day we're everyday Americans. Oh, every day we're everyday Americans.
Hello there, everyday Americans. Paul Engel here with the Constitution Study, where we read and study the Constitution. Teach your generation be free. Glad you could join me today. The legislation we're looking at is not unique. It's been tried before. To my knowledge, it is yet to actually pass, but it's still being worked on, and that's important. If at first you don't succeed, try again. Now, you can find all the links and references and stuff on the written article on the website, constitutionstudy.com. And of course, I'll talk more about the website and some other ways you can support the work that we're doing here at the end of the episode. But for now, let's talk about the Texas Sovereignty Act. The Texas legislature attempted to pass a bill some have called the Texas Sovereignty Act. The stated purpose of the bill was an act relating to the authority of the legislature to determine that certain federal directives are unconstitutional and to prohibit certain government officers and employees from enforcing or assisting in the enforcement of the directive. Now, Texas was not the first state to consider such legislation, and I can only hope it won't be the last. This time, the bill died in the state Senate. However, I still think it's worth looking at both in the hopes that the Texas legislature will pick this up again in the future and that other states will be inspired to do so as well. To understand this legislation, we need a bit of a history lesson on the United States of America. All the way back in 1776, the 13 colonies declared themselves free and independent states. From the Declaration of Independence, we read, "We therefore, the representatives of the United States of America, in General Congress assembled, appealing to the Supreme Judge of the world for the rectitude of our intentions, do, in the name and by the authority of the good people of these colonies, solemnly publish and declare that these united colonies are, and of right ought to be, free and independent states, that they are absolved of all allegiance to the British Crown, and that all political connection between them and the state of Great Britain is and ought to be totally dissolved, and that as free and independent states, they have the full power to levy war, conclude peace, contract alliances, establish commerce, and do all other acts and things which independent states may have right do." Now, these brand new and independent states recognize that they would need to work together if they were to survive, especially against the mother country, Great Britain. Now, Congress proposed the Articles of Confederation in November of 1777, and it was ratified by the new states in March of 1781. Within this document, the states adopt a name for their new creation. Article 1. The style of this confederation shall be the United States of America. The Articles of Confederation did not last long. It was replaced in 1787 with the Constitution for the United States of America. Now, most of us probably remember the opening to the preamble of this document. "We, the people of the United States, in order to form a more perfect union." Now, it's important to remember that the Constitution did not go into effect until the states ratified it. From Article 7 of the Constitution, the ratification of the conventions of 9 states shall be sufficient for the establishment of this Constitution between the states, so ratifying the same. This means that the Constitution is an interstate compact. Going to the Free Legal Dictionary, we find the term compact is most often applied to agreements among states or between nations on matters in which they have common concern. This also means that the states are parties to the compact, and since the federal government is a creation of this compact, the states not only created the federal government, but delegated to it limited and enumerated powers. From the 10th Amendment, the powers not delegated to the United States by the Constitution, nor prohibited by it to the states, are reserved to the states respectively or to the people. As parties to the Constitution, the states, and only the states, have the power to amend the document and thereby modify the powers delegated to the federal government. So if the states created the federal government, If the states are the only entities that can delegate powers to this government, why do so many state governments act as subjects of the federal government rather than its master? From my research, I find two reasons for this power inversion. First is a misinterpretation of the Supremacy Clause, Article 6, Clause 2 of the Constitution. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under the authority of the United States shall be the supreme law of the land, and the judges in every state shall be bound thereby, anything in the constitutional laws of any state to the contrary notwithstanding. Now, law schools teach, and it's widely accepted, that the Supreme Court is the supreme law of the land. They may not use those words, but that's the impact of their teachings. However, a quick look at the Supremacy Clause shows that court decisions hold no position in the supreme law of the land. In fact, judges in every state are bound to the supreme law and not the Supreme Court. It's also taught and accepted that any act of Congress signed by the president supersedes state law. Once again, a quick look at the Supremacy Clause shows that only laws of the United States which shall be made in pursuance of the Constitution are the supreme law of the land. So if Congress or any other part of the federal government act in a way contrary to the Constitution of the United States, what can be done? Second is the fact that, based on my research, the Constitution is no longer taught in our law schools. This indoctrination of our entire legal system has led to the idea that the states are subdivisions of the federal government, not its creator and master. If attorneys had studied the 10th Amendment and the Necessary and Proper Clause, then maybe the need for states to reassert their sovereignty would not be necessary. This is where the Texas Sovereignty Act and other acts like it come into play. Reading from that act, under Section 1, Subtitle Z, Title 3 Government Code is amended by adding Chapter 394 to read as follows: Unconstitutional Federal Directive. This would not be the first time that states declared the acts of the federal government unconstitutional. The most famous of these happened back in 1798 with the Virginia and Kentucky resolutions. From the Virginia resolution, that the good people of this Commonwealth, having ever felt and continuing to feel the most sincere affection for their brethren of the other states, and truest anxiety for establishing and perpetuating the union of all, and the most scrupulous fidelity to that Constitution, which is the pledge of mutual friendship and the instrument of mutual happiness, the General Assembly doth solemnly appeal to the like dispositions of other states, in confidence that they will concur with this Commonwealth in declaring, as it does hereby declare, that the acts aforesaid are unconstitutional, and that the necessary and proper measures will be taken by each for cooperating with this state in maintaining unimpaired the authorities, rights, and liberties reserved to the states respectively, or to the people. I wrote about these resolutions, including the outcomes, in more detail in my article, Can States Rein in the Federal Government? In more recent years, many states have also considered similar legislation, while others simply ignore federal laws like those involving the use of marijuana or assisting the federal government in enforcing their immigration laws. Now, a move of this importance should not be left to whimsical decision-making. Under Section 394.002, the legislature, by concurrent resolution, may determine that a federal directive is an unconstitutional federal directive and prohibit a government officer or employee from enforcing or assisting in the enforcement of the unconstitutional federal directive. The Texas legislature also recognized the constitutional authority of the federal government to call up the state's militia. This section does not apply to a federal directive that activates the state military forces as defined in Section 431.001. This act would have also required the legislature to be specific about which federal acts were unconstitutional and their impact on state officers and employees. Subsection 004. The legislature may not adopt a concurrent resolution described in Section 394.002 unless the resolution identifies the federal directive that the legislature determines is an unconstitutional federal directive, explains the basis for the legislature's determination, specifies whether a government officer or employee is prohibited from enforcing or assisting in the enforcement of the directive, including specific activities or forms of assistance that the officer or employee may not engage in, specifies the government officers or employees to whom the concurrent resolution applies as applicable, and specifies any other requirements the legislature considers appropriate to impose on a government officer or employee in order to comply with the legislature's determination. Such a concurring resolution would have required a two-thirds majority for passage. Such a resolution could be repealed, again, but only by a two-thirds majority. Lastly, the act would have made a statement about legislative inaction. Subsection 007. The fact that the legislature has not considered whether a federal directive is an unconstitutional federal directive under this chapter does not imply or create a presumption that the directive is constitutional or limit the authority of the Attorney General to challenge the constitutionality of the directive. Now, overall, this appears to be a reasonable and logical way for a state to reassert both its sovereignty and power as a part of the Constitution to oversee their creation. Sadly, this bill did not pass the Texas Senate. I'm not sure why, but I can take some reasonable guesses. It appears that more state legislatures are controlled by attorneys, not just those members who have gone to law school, but it's my understanding that any proposed legislation is frequently passed by attorneys for their opinion before it is debated. Now, since it is probable that the attorneys that are reviewing this legislation haven't actually studied the supreme law of the land, I can see where their opinions about legislation would deviate from what the Constitution actually says. It's also possible that the state legislatures simply don't want to pick a fight with the federal government, regardless of why this bill failed. Now, as we've all heard, if at first you don't succeed, try again. I would suggest that not only to the legislatures and citizens in Texas, but to all the 50 states. Because if you want to understand why the federal government is out of control, regulating just about every aspect of our lives, the answer is because the states don't stand up when the feds went too far. If you want to know why the federal government has a $37 trillion deficit, it's because the states didn't stand up when the feds embezzled money from their citizens. And if you want to know why the states didn't stand up, it's because we, the people, have hired representatives who are unwilling to stand up and protect our rights. Now, whether you're in Texas or another state, it's time we take legislation like the Texas Sovereignty Act and get our representatives to push it through. It is the only legal way to rein in an out-of-control federal government. Now, I'm not saying the feds will meekly submit. In fact, I expect them to fight tooth and nail to maintain their illegal ways, which is why we need people of character to hire representatives of character at both the state and federal level to follow the supreme law of the land. That's the only way we restore the rule of law to this great nation. So the Texas Sovereignty Act did not pass the Texas Senate. That's okay. It's not the outcome we wanted, but it's the outcome we have, which means it gives us an opportunity to talk about such things as state sovereignty and limited enumerated powers for the federal government. It allows us to talk about the role of the states overseeing their creation housed in Washington, D.C. It's the opportunity to talk, to discuss, to learn, and to enlighten. But that only happens if you actually do the work. That's why John Jay said every member of the state ought diligently to read and study the Constitution of his country, teach a rising generation to be free. And it's the reason why the Constitution study was created. It was created so that we could read and study the Constitution, to encourage people, to help people, to answer questions. That's why I wrote my book, The Constitution Study, to give people a chance to read and study the Constitution in a form they could easily digest. Not legalese, but plain conversational English. It's why I put out these videos. It's why I put out the podcast. It's why I write it's why I spend so much time doing this. Now, it's not easy doing all. It takes a lot of work, takes a lot of time, takes a lot of effort, and it does take money. So you can help. You can go to the website, constitutionstudy.com/shop, purchase a book, purchase a t-shirt, purchase a mug, or just donate to the cause. Now, I'm not a 501c3, but every dollar you spend there goes to keep the Constitution Study up and running. I don't draw a salary, and well, no one in my family does either. You can also work with our affiliates, like the Miracle of America. This great course I found that really looks at our history from the Pilgrims through the founders and helps explain why the states created the federal government the way they did, why they drafted the Constitution that way, why the Declaration of Independence was written that way. I liked it so much I made a deal with the owner to get you a lesson absolutely free. That's right, you can try it before you buy it. Just go to constitutionstudy.com/1776 study guide. That's the numerals 1776 study guide. You'll be taken to a custom landing page where you can read up on the course and on the instructor. But best of all, you can enroll for a free lesson on God's natural law, the foundation of our unalienable rights. You get an hour of content, audio or video, you get a downloadable study guide, and you get it all absolutely free. And if you like that lesson, you want to take the whole course, sign up there. It's just $17.76. But that journey starts by going to constitutionstudy.com/1776 study guide. You can also help with your cell phone. Patriot Mobile is America's only Christian conservative wireless provider. Best of all, they share our values. They support organizations like the Constitution Study and others that are trying to protect your rights. Just go to patriotmobile.com/constitution and find a plan that works for you. And then use the code Constitution at checkout to get free activation. Once again, that's patriotmobile.com/constitution to find a plan that works for you. And don't forget to use the code Constitution to get your line activated absolutely free. Now, whether you support us directly or through our affiliate or just listen to this content, I hope you'll come back and join us here as we learn and read and study. And hey, maybe you can bring a friend or two the next time we meet here for the Constitution Study.